We are moving a step ahead wherein we are going to discuss the criterias of patentability in detail, as well as how patent office accesses or assesses this particular criterias for patentability. Only three important criteria for patentability are applicable at the top level, and if you satisfy those top level criteria, only then the other criteria mentioned in the earlier slide are actually checked. If any of these the top level criteria are not corrected or not checked, they will not grant you a patent for, irrespective of your invention may be very useful in nature, but they will still not grant a patent for it because your first initial criteria may not be considered applicable. First and most important part is novelty. Novelty, as I told you yesterday, the novelty is also interchangeably referred to as or also known as uniqueness, also known as newness, and ultimately the definition of all these things are similar. So in India they refer to as novelty, whereas in United States they refer to as uniqueness. Ultimately the concept remains the same. So what novelty means is that any concept or any idea or any invention that you are planning to file as a patent application should not be a state of art, or prior to the date of filing it should not be disclosed to anybody in any form, right? So let's take an example. I have a very good invention in my mind and it solves so many problems, but what I do is like I publish it in a newspaper before filing a patent application. Publishing it in a newspaper, don't you think that at least one person in India, at least one, the person who actually prints the news, he must have read that? Obviously, yes. So if such is the scenario, and irrespective of how many people bought that newspaper or not, but if it is published and if it is accessible on the internet that this document or this invention was published in the newspaper before the date of filing the application, you will not be able to satisfy this criteria and you will never get a patent granted for it. Another example, out of excitement, somebody found a solution for this, or a vaccine for this COVID-19. Right? It's a rocket. It's a breakthrough technology. Till date, there is no vaccine for COVID-19, and this person just came up with a vaccine which is very effective in nature. But what he did was like he immediately went on a YouTube channel and shown a video or a demonstration of that vaccine or the effects of that vaccine. And then on the next day, he goes to patent office and files a patent application for it. What will happen is like during examination, the patent office will fix the date on which you have filed the application, and any literature or any prior art before this date would be considered as known to public or known knowledge of a public. And thus, that video of that person who has published it one day prior the publication, the filing of the patent application, based on that, they will say that your invention is not new because you have already published in a public domain. You will not get a patent for it. Right? Third example is that you publish it either in a kind of IEEE research paper or in a thesis or in a journal which is accessible on the internet. So you, before filing a patent application, you decide to go and publish it or file a kind of research paper which is published before you file a patent application, would obviously be a part of a public record or a prior art, and you will never be eligible to get a patent. Now, this is most important point here from the perspective of India. However, in United States, what happens is like in US, there is a concept called as grace period. So according to this grace period, even though a person who has published his invention in any form, that may be a YouTube video, that may be a IEEE journal, that may be a thesis, that may be a a kind of newspaper article, he may for the next 1 year from the date of publication can file a patent for it and still be considered as patent eligible subject matter only in United States. But this is not applicable in India, right? We have seen so many faculty members and so many people across the globe who came up with similar kind of situation wherein out of excitement during their college days they filed a IEEE research paper and they published it and they were very happy because their CV seemed to be strong. But now when they are working in research and development, they came to know about patent and now they want to get it patented. And then when we tell them this criteria, that it really breaks their heart. So what I would like to suggest here through this particular criteria is that Please, if you are interested to file a patent application and if you feel that your patent application can create some difference in the existing technology or knowledge, you should file a patent application and then plan to publish it in a article. Now I am stressing on the term publication. Okay, so we should not get confused that if a IEEE research paper is submitted and it is not yet published, that does not mean that your novelty is destroyed. That does not mean that it is published, right? Only when it is accessible on the internet before you file a patent application, it is considered as a published one. Similarly, the video that you have taken and you plan to launch in YouTube, if it is published on the same day that as that of the patent filing, that does not break your novelty. But any day before the date of filing of a patent application, if it is available on the internet, then it will create a problem for you. So these are nothing but the accessibility criterias for, or let us say, how a novelty assessment is done by the patent office. So, like I said, any invention is considered as novel if it has not fallen in the public domain or it is does not form a part of the state of art before the date of filing of the application, right? So, another example of this particular thing is like I have come up with a very good invention and I have started using it in the market just to check whether there is an efficiency in that or whether it works. The best example of this is COVID vaccines. I may not be able to come up with a testing results until I test it on people. That means I have to use it before I file a patent application. Otherwise, it will be a kind of hypothetical in nature, right? So in such cases, government says that even if you want to do any kind of testing, you do it in a hidden form or at least with a group of people who do not disclose the effects thereof outside this particular thing, right? So even though if it is prior use, you cannot consider a kind of exception there in that cases. But yes, there are a couple of exceptions for that. One example of that is if you come up with an invention which is associated with a tar road, the road that we see on the streets, right? Now this tar road cannot be done in a house, it cannot be done in an institution, it cannot be done in a building. It has to be a public display, otherwise how will one check whether there is a sustainability of this particular road, tar road, right? So such inventions has an exception, and if any person does such kind of demonstration on the road and even if it is known to public, for next 1 year it is secured even in India. And for such inventions, patent office allows the kind of exception, and you can consider pursuing your patent if you file the patent application within 1 year from such public display, right? Similarly, another example is what we can have another example of a ship, cruise ship. So if we come up with a very beautiful cruise ship which not only is operable in the sea, but it can also be used as a two-wheeler vehicle or four-wheeler vehicle on the road, right? So it is very unique concept in itself. So if anybody come up with such invention and if they implement that product, obviously they cannot drive a ship in their home or in their water tank or in their swimming pool. They have to take it to a sea. There will be people who, while taking it to the sea, they will see that particular product and it will indirectly come to the knowledge of people. But patent office says that obviously because there was no other option and you did it for checking the trial or testing the product, you will be allowed to file a patent application within 1 year from the date of such publication, and patent office will ignore that prior art which was published. Okay, these are all exceptions that we are referring to, but at the moment in India the concrete rule says that irrespective of whatever reason it may be, if you publish your invention outside in any other form or any form, we will not consider your application for granting, or during examination we will raise the objection of novelty. An invention lacks novelty if the specified combination of features have already been anticipated by a previous disclosure within a single document. Now let us assume one person being very smart, what he realized that there is a product which is available in China but it is not available in India. Okay, or for that matter, if there is a product that is available in United States and you saw that from last couple of years that product is available in those countries and nobody has bothered to file it in India or use it in India. So this person, what he does is like he tries to file a patent application for that product which is already known in the public disclosure or already known in the any document that is mentioned there, right? So such inventions will also not get a patent granted for it, because as the criteria is very simple that your invention which you are filing for a patent should not be published. So there is no criteria that you yourself should not publish it. Any person who has published such invention in the art Published as in like known to a public domain or known to public, which can be in the form of product, which can be in the form of video, which can be in the form of any form which is accessible on internet. And if it is available, which are published by any XYZ person and not you as an inventor or applicant, you will still not be given a patent granted for it, right? For example, if you read it in a newspaper about an invention which is used in for example in China or Japan or Pakistan, and you realize that this is nobody has filed a patent for it, but it is there in newspaper. So what you do is like you copy that invention and file the patent application for that in India, under the impression that since this product is of Pakistan, nobody must have read it. But that's not the fact. When the search of the results for novelty are done, they always check from the perspective of the global availability. So if it is available in any country across the globe, even though the patent is a territorial right, you will still not be allowed to get a patent granted, because the law says that there has to be only one invention and there has to be only one patent for it. No one invention can have multiple patents for it. This is clear? Perfect. Moving on, the second and most important criteria that we discussed about for getting a patent is inventive step criteria. So what does inventive step criteria says that your invention, there are three basic important parts for it. The definition that you're seeing in the inventive step is actually a definition which is uh, taken from the Patents Act. So this definition is very important. A feature of an invention that involves technical advancement as compared to the existing knowledge, or having an economical significance, or both, and that makes the invention not obvious to a person skilled in art. Since this is a bookish definition and it's a law, I don't think so there will be many people who will understand that. Let me make it further simplify for you. This criteria says that if your invention has technical advancement, what is the meaning of technical advancement here is that if there is a technology which is already existing in the market, and you have tried to improve that particular technology, and the solutions or the results provided thereof are better as compared to the existing one, that is referred to as a technical advancement. And hence the term used is along with technical advancement as compared to the existing knowledge. That means existing literature, existing product, existing technology, existing solutions, all these things are considered as a existing knowledge, and any improvement in such existing knowledge can be considered as patent eligible subject matter. It again have further criteria, or it should have a economical significance. That means your invention should either have a technical advancement or it should have a economical significance. For example, if there was a product which was available in the market and it was sold for around 5,000 rupees, but you have come up with a similar product by doing certain modification, or for using some different material altogether, and such product can be sold in 500 rupees. There is substantial difference wherein a common public can afford that particular um, product. So if such is the criteria, wherever the economical significance or economical difference is there, you can consider that your invention satisfies the criteria of the inventive step, at least the part 1 criteria of the inventive step. The part 1 criteria says that it should involve technical advancement, or it should have economical significance, or it can have both. It can have technical advancement as well as economic significance. So either of these three criteria needs to be satisfied. If it is satisfied, that means your invention has satisfied one of the criteria. And second part of this inventive step definition says that your invention should make the invention non-obvious to a person skilled in the art. So yesterday also we focused on the terminology person skilled in the art, and today in the definition of inventive step we are again seeing that particular part. Non-obvious criteria is really very important. So for example, let us understand, let's take a simple example of a pen. Like yesterday also we discussed the same example of a pen. If a person tries to replace the blue color ink from the blue color refill of a pen with a red color, right? Let us assume that till date there was no such inventions which is of red color pen. But this guy, what he did is like he saw a blue color pen already in existence, existing knowledge, and he just replaced the ink of that blue color pen using red color. What do you feel? Is the invention obvious? Or whether the person should be given a patent for it? According to the law, the patent law, and especially the inventive step criteria, the patent office indicates that any invention which is very obvious to a person skilled in the art, that means a person who is working in a industry of that particular domain for which the invention is filed, and if he is saying that by seeing the document or by seeing the inventions itself, it seems to be obvious, you will never get a patent granted for it. In the example of pen, either a person working in the color industry or a person working in pen manufacturing or refill manufacturing industry, he would be considered as a person skilled in the art. And if such person says that replacing the blue color of the ink from the refill is very obvious to replace it with red color or any other color, then it will be considered that your invention is obvious and you will not get a patent granted for it. The definition of inventive state that your invention should not be obvious. It should not be. Right? This is very important to understand. So you may have noted in this discussion that inventive step has two sub criteria. One sub criteria says that your invention should have a technical advancement or economical significance, or it should have both. And second sub criteria says that your invention should be not non-obvious to a person skilled in art. Now, how it is decided that whether our invention is not obvious or whether our invention has technical advancement or not? So there are some criteria or some assessment rules at the patent office which are followed to establish this particular criteria. The one of the most important criteria says that yesterday also we discussed about the same thing. There has to be a problem solution approach. Okay, so problem solution approach means that, or failure of others, that means if in the prior art, if inventors have tried to solve a particular problem in the existing technology or existing art, but they were not successful, right? I hope the scenario is clear. There was a product which was existing and there was some problem associated with it, but there were many attempts made and they were not able to solve that particular problem. But fortunately, one person was able to solve that particular problem, and this person comes and file a patent for it. Obviously, it will be considered as involving inventive step because there was a problem which was not solved, and there were proof that many people attempted it and they were not able to solve it, and hence the invention is considered as a inventive invention, or it has an inventive step. That means it has a technical advancement over the prior art and a solution according to it. So problem and solution approach is very important. Complexity of work. If the work undertaken by the inventor in order to produce the invention was particularly complex and not readily carried out, that is an indication that it was not a matter of routine. In such cases, the inventions can be non-obvious. As the definition is pretty much clear, it indicates that if there was something which was available and nobody has tried to attempt to solve that, right? Nobody has tried to do that. Let's take an example. We all know that the sunlight that we receive, it includes a source of energy called as solar energy. Till date, many people have converted the solar energy into the electrical energy, or for example, the solar heaters and solar other equipments. But nobody must have attempted that solar energy can be used for charging a mobile phone without even using a charger. So as soon as you keep your phone in sunlight, your phone will start charging. Isn't it interesting? There may be people who have attempted to do that using the photons of the sunlight. They may have tried to charge their battery without requirement of any external source of connection between the electricity or anything like that. Just hold your phone in sunlight and your phone will start get charged. Many people must have tried, they have failed miserably, but at the moment there is no such invention that is available in the art which says that sunlight can be used as a source of charging directly without doing any modification to the existing one or without requiring any intermediate apparatus. Such inventions would be considered as patent eligible and inventive without any question. Is this clear? Let's take another example which we also discussed yesterday. So for example, if I want to run my car on water, sounds funny, I want to run my car using water. I don't want to use any fuel inside it. I just want to use water inside the instead of petrol or diesel, and I want to run this particular vehicle. Till date, nobody has tried to do that. Nobody has attempted that. And even if somebody must have attempted, they may have failed miserably and made joke out of it, right? But one day somebody come up with an invention wherein he says that by doing XYZ modification to a engine, water can be used as a source of fuel and I can still run my vehicle on water. It will be a breakthrough technology. So the complexity of work and failure of others combinedly work in such examples, and you will be allowed to file a patent and get a grant of it, and there will be no question of inventive step in such examples. Right? Third and most important part is commercial success. Now, for example, why commercial success is a part of inventive step? Because let us assume that if you're the same example, if a product was available, it was available for rupees 5,000 in the market today, wherein common people are not able to buy it or purchase it and use it for their own benefit. You will never attempt to buy that particular product because it is very costly. But you come up with a different type of product of a similar reputation and similar purpose, and you decide that this I will sell it in 500 rupees, and there is suddenly so much of demand that this product actually got a good reputation in the market. Such criteria can also be considered as a assessment principle of filing a patent or inventive step, because the definition also clearly indicates that your invention should be non-obvious, but above that it should have or it can have economical significance to it. Right, this is clear. I hope this is clear. Any questions, please do not hesitate to ask me in the after session requirements or questionnaires from your side. I'll be very happy to answer those questions. The next criteria here is industrial applicability, which we discussed. As the definition is pretty much clear, the industrial applicability criteria says that the invention, according to the Patent Act, should be capable of being made and used in industry. So, as the definition says, it has two parts. One is it should be capable of being made, and it should be capable of being used. Made and used are two different parts. Sellers and users, or manufacturers and users, are the two criteria here. So your invention should be something like people in the industry or a manufacturer should be able to make it. And second is your invention should be like that after making such product, people should be able to use it. If either of these criteria fails, that means either you are not able to or the competitors are not able to make your product, and or the users are not able to use your product, your invention would be considered as non-patentable. That means your invention is hypothetical in nature, right? It is completely hypothetical in nature. So this is what is the third and required criteria of industrial applicability, right? I hope these 3 points are clear to you. Firstly, what are the criteria that we discussed, and then we discussed what are the specific assessment criteria. We are not going to go into further detail of patenting in this slide. We are going to discuss, because we have already touch based, and I want you to digest these things first, and then we will move on to the specifics or the requirements of the patenting. So just to get some air in the discussion, we are going to discuss and focus on different types of patent application that can be filed in India as well as across the globe. The first type of patent application is called as provisional application. If you recall, I have already very briefly discussed about provisional and complete application, I think in the second session yesterday. So provisional application is also referred to as a temporary application number, and it is generally filed only when you do not have complete details about your invention at the moment, and you want to do some testing, research and other stuff to include to ascertain whether this invention will work or not. In other words, your invention, you may have a concept or idea in your mind, but you may not have the implementation details associated with that concept or idea. And in such cases, government says that you can file a provisional application with that idea or concept, and we will give you 12 months of time to file a complete application for this particular invention. So once the provisional application is filed, government gives you a 12 months of time to file a complete application. Let me compare this thing with a real-time example like we discussed yesterday. Before you get a permanent driving license, you are always given with a temporary driving license. But there it is always happens. Here it does not happen always. So if at one point of time, if you feel that you have all the data associated with the invention available with you in terms of what is your invention, how it works, what all problems it is solving, what all components are required for implementing that invention, if you already have that, then you don't have to file a compulsory provisional patent application. You can directly file a complete application. Provisional application is for those people whose invention is in a idea or conceptual stage. And second, if they are in rush of publishing their invention, maybe in newspaper or maybe in any article, or they themselves want to publish it on a YouTube video. Let's take an example of this scenario. So for example, if today I come up with a COVID vaccine, which is very helpful to each and everybody across the globe, and I know that I do not want to wait for a single moment to even launch it in the market or use it in the market for people. But as soon as I decide to use it in the market, the novelty of the invention is lost. So what I would do is, like, I will try to file a provisional application immediately today with whatever details I have about the invention in terms of formulation, storage capacity and other things, how it will or how many days it will take to cure, whatever information I have, I will try to put it in that document. I will file it at the patent office as a provisional application, and I will be given a patent application number and a date on which we have filed this application. And then immediately after getting that application number, you can start selling, you can start branding, you can start using that particular COVID vaccine in the market, because government has given you that right. Firstly, the date on which you have filed the application, and secondly, a 12 months of time to file a complete application about that invention. So in this 12 months of time, what you can do is, like, you can test this particular vaccine, you can generate results for this particular vaccine, you can compare this vaccine with any other vaccine that is available, we call it as comparative analysis, and then submit all these details along with the results of this particular thing at the filing of complete application, right? This is what is the purpose of provisional application. Let me reiterate, it is not mandatory to file a provisional application. Provisional application is only filed when you are having the idea or concept in your mind, but you don't know at the moment how to implement your invention, or if you have the complete details about your invention available with you, but you are in rush of publishing your application or publishing your invention to a public, and you may not have time to draft the complete application, that is the time when you decide to file a provisional application. These are majorly only the two criteria or two conditions when a provisional application is to be filed, right? No patent is granted on the basis of provisional application. As I told you, if you fail to publish or to submit the data associated with the complete application within 12 months, your this provisional application which was filed at the patent office is considered as equivalent to not filed, and it will get abandoned. It will get withdrawn. So nothing will happen about the provisional application. So this temporary application goes to when? Similar to your driving license, when you apply for a driving license, you get a temporary license and you are given a date, or let us say within next 6 months, you have to apply for a permanent license. If you don't apply for permanent license within this 6 months, your this time period of provisional, or let us say the temporary license, further extends to next 6 months, right? Similarly, for this case of provisional patent, if you don't file your implementation details or complete details in the complete application within 12 months, your this application gets cancelled. Provisional application gets cancelled. Unfortunately, when we file a provisional patent application, there are no legal patent rights given, because obviously legal patent rights are only applicable when the patent is granted, and since provisional is just a temporary one, you never know what would be the fate of the patent, and thus no legal rights are being granted.